Muy buenas tardes. Muy
Institute at the Wilson Center. Thank you all for joining us. It's my pleasure to welcome you to this conversation with Alfredo Rendón, Director General del Instituto Mexicano de Propiedad Industrial, or IMPI, Mexico's patent office. I've worked with Alfredo for many years, and it's a real pleasure to have him with us, albeit virtually. There's no question that innovation is the motor of national growth and development. To foster innovation, it is essential to protect intellectual property, including patents, copyrights, and trademarks. The certainty that innovators will be able to commercialize their inventions in the manner they wish is one of the central drivers behind the investment in time and money made by those innovators on a daily basis. The role of IMPI and its Director General is to promote and protect the development of new inventions, new works of art, new books, music, and other creations. In a world in which more and more activity occurs in the cloud, the protection of inventions and creations that come from the human mind is even more critical. This afternoon, we'll hear directly from the Director General about the institution's plans to carry out its responsibilities and to facilitate the entry into the Mexican economy of small and medium-sized enterprises, as well as women-owned businesses, both of which are priorities of the AMLO administration, as well as the Biden administration here in the United States. After we hear from the Director General, we'll have time for a conversation, including questions from our audience. So if you have a question, please send it to mexico@wilsoncenter.org or tag us on Twitter @Mexico Institute. The Director General will speak in Spanish with simultaneous translation into English. We will post a recording of the event in the original Spanish on our webpage in a couple days, as well as a recording in English. Alfredo Rendón has more than 25 years of experience in industrial property. He served as Deputy Director General of Industrial Property in charge of the Patent, Trademark, and Intellectual Property Protection Divisions, and previously as Divisional Director of Legal Affairs, among other positions at IMPI since 1994. He also has extensive international experience in intellectual property. He participated in the negotiations for the US-Mexico-Canada Agreement, the modernization of the treaty with the European Union, and the Comprehensive and Progressive Agreement for Trans-Pacific Partnership, among others. He has represented Mexico in the World Intellectual Property Organization, where he currently chairs the Permanent Committee on Trademarks, Industrial Design, and Geographical Indications. Alfredo Rendón has lectured in Mexico and other countries and has been a professor of law. He himself holds a law degree from the Universidad Tecnológica de México, a postgraduate degree in labor law and intellectual and industrial property from the Universidad Panamericana, and a master's degree in business administration from the Universidad Interamericana para el Desarrollo. Alfredo, welcome to the Wilson Center. We're delighted to have you here and looking forward to hearing what IMPI is planning.
Buenas tardes, gracias, Andrew.
Good afternoon. Thank you, Andrew. It's a pleasure to be able to participate in this forum that has been called by the Wilson Center, and I thank the organizers to be able to talk within a specialized audience all the elements that have to do with the implementation of the industrial property law in 2020 for the Mexican system of intellectual property and the way that the Mexican Institute of intellectual property type of work known as IMPI. Let me express my gratitude to Andrew for the logistics and the call behind all of the preparations in order to have this event. Very briefly, and just because we need to understand the current intellectual property system in place, I will start my presentation with a brief narrative of the legislation in this area. I will give you some background of intellectual property law from 1994. Now, by speaking about almost 30 years, this legal order had as one of its intentions to comply with the commitments acquired by our country in the signing of NAFTA in 1994. As a part of these goals, and purposes, we identified that through a legal act, we will give administrative quality to IMPI and intellectual property in industrial property. Up to 1994, it was a body of support to the Ministry of Commerce and Industrial Property in this particular area, industrial property. Now, as time has gone by, the economic and social conditions of a country do change, and Mexico is no exception to this. These changes, the technological advancement, but basically the modernization of the free trade agreement between Mexico, Canada, and the United States made it necessary to create a new legislation in this area. By doing this in 2020, we dismissed the intellectual property law and we published the General Act of Protection of Industrial Property. Before we analyze all the changes as a result of this law, let me highlight that one of the priorities in order to carry out this legislative transformation was the technological updating of IMPI with the intention of providing a better service for the benefit of users and to have new elements of protection basically in the digital area. The world has changed, and in 1994, we did not have the problems that we had in 2020, basically, as I have mentioned in the digital report. It was most important that we will legislate within the law the presentation and the processing of the different applications that most of the countries were already doing. And though at IMPI, this update had been worked technically, given security, legal certainty, it was indispensable that we will clarify all the requirements and the way of working in the electronic means within this act. Now, mentioning that the intention was to modernize the ways of working with the industry, I would like to share with you the different areas that have to do with the implementation of the Industrial Property Act, starting with the chapter of patents. This new act in the area of inventions regulates precisely the mechanism of direct coordination between IMPI and the health officials, COFEPRIS, to make efficient all the tramiting demanded by this government body in regards to industrial property rights. In the same way, we present specific processes for the rectification and limitation of rights from the bearer of a patent or the rights of a patent in order to have flexibility conditions in regards to their interests. As it is the case in other countries now at the legal area, we have now the Volar clause that regulates the elements in order to get the health registries of patents that are just about to be due or be of public domain regarding drugs and medication. In this area, patents, it gathers the best practices of other countries and it tries to place ourselves this within the standards of our main partners, of course, including the United States. In the area of changing brands, and the changes were minor because this chapter had been reforming partially. But it's important to mention that at present, in the area of geographic indications, we have the elements of selective brands, geographic indications, and origin denominations. Through this, we are at equivalence with the market of the United States for the regular standardization and trading of the products that are known as traditional or emblematic of the different countries. With no doubt, the most important changes took place in the area of intellectual property. That is called the enforcement area. I start this area by pointing out that now we have defined parameters for the implementation of traditional measures in the digital environment. These parameters are supported by the Supreme Court criteria in regards to what has been mentioned previously. The Supreme Court said that for the implementation of these measures, they had to be foreseen within the law. We have them now within our legal standards, and we have an act that follows the jurisprudence and the decisions of the court. The Supreme Court has mentioned that these rules should be based on a legitimate purpose. This is allowing within the new act the ponderated studies of what is called the good right. That means that we will reasoning the causes for which they're imposing or raising some measures, not only in the digital environment, but in any other environment. In summary, now it foresees within the new legislation the partial blocking that is proportional to the limited right. Within the same website, we can block a section or all of it. It's up to the nature of the right that has been called as affected. Now, by concluding this area, we consider provisional measures against the violations of rights of intellectual property in the digital environment. And what's important, we include virtual inspection visits. Not only we will have inspection visits to physical establishments. Another relevant change is the possibility of fighting illegality to industrial property rights when it has to do with transfers of trade or merchandise. Nowadays, it's possible to suspend the circulation of merchandise and their entry to the country only to carry out the transiting of them. In the previous law, in the law of 1994, we had not considered this element that left a legal void in order to ensure or seize merchandise that were not going to be merchandised and were not to enter our country. Now we are capable to ensure this type of products. We can seize them. Why is this important? Well, though we knew that technically these products were not entering our country, they were using Mexican ports to take them to other places, but they will come back to the Mexican market, or they will use for others the benefits of the free trade agreement in order to enter other countries. Most surely, the United States was no exception, and they were using Mexico as a bridge in order to bring fake products to the U.S. markets. To continue with provisional measures, a constant complaint of the right bearers was the automatic implementation of measures through the simple presentation of a counter bond, and the only requirement was it had to be 40% above the collateral bond presented by the bearer of the right. Let me explain. If the right bearer will present a request or an application of measures, and it will have, let's say, a collateral of $100,000, the infringent only had to pay 40% additional of this fee, and then measures were to be raised. That is not the case. The National Federal Law of Intellectual Property Protection gathers the criteria expressed by the judicial bodies presented by the Supreme Court, and also the problem expressed by the right bearers in different fora. And now, in order to raise the provisional measures, it will not be enough to present a counter bail or a bond. But now we have to support and motivate all of these elements by ensuring the protection of the right bearer, by preventing all these fake product circulation, and not to impact the public order nor general interest. In addition to this, raising the provisional measures as a result of this counter bond or bail had to do with all the problems because the fines imposed by the industry were really a laughing stock, and they took so many time. It could take us 7 years or 8 years in procedures and then go into the area of harms and problems or damages. Now, after all of this, as it is mentioned in the free trade agreements, basically that between the United States and Canada, the sanctions had a substantial increase. Now we can sanction the infringer with the amount equivalent to almost $2 million and $4,000 for every day that this infringement will continue. I want to clarify that these are magic amounts, and the determination of the sanction will be analyzed case by case, discussing the elements regarding the conduct perpetrated by the infringement. Let's say if it is a minor manufacturer, we cannot impose a $2 million fine. It will be impossible to pay it. It has to be proportional to the economic capacity of the infringement. Uh, Now, in accordance to the procedures that I have mentioned a little while ago, could be very long, would take 5, 7, 8 years. Now, before the Institute, we can start a file of harms and damages. Previously, it was only a function of the judicial branch, but only once the infringement was decided by IMPI, this process could start. Now, with the new legislation, the right bearer could come to the civil judge if they wish to do so, or even before IMPI, to start an application for the process of harms and damages and to identify the amount of these, to determine the damages, and elements could present the Institute and it should accredit the perpetration of an illicit act. This will be identified with the determination of the Institute to sanction this. It also should accredit the materialization of a damage caused to the applicant and also the behavior and the damage perpetrated. Now, with this same intention of reducing and simplifying this procedure, now in the cases of this, uh, and the possibility of acting of the private sector, basically the cost. We know that lawyers in Mexico and all over the world are quite costly, and this process implies cost. So the National Act of Industrial Property formalized within this context an alternative dispute settlement mean, which is conciliation. We were doing it, but it was not foreseen in a law. It was totally off informal basis. So now this conciliation has the following steps: the presentation for conciliation, the mission of these decisions by the institute, that the counterpart will comply to a conciliation process or mediation process, and given the case, to present a counter proposal. With this process, the intention is that the parties, in a common way, will settle the disputes, eliminating all the procedural burdens that take place in a formal process. Finally, let me refer to a very relevant topic, which are called the technological protection measures that were a subject of broad discussion in signing the free trade agreements in different fields. How do we understand the technological measures? They are a layer of protection that copyright artists, interpreters, singers, producers, etc. And one of the main goals of this protection are the suppliers of internal services. The ones that are called PCI are, for the purposes of the law, only intermediaries that broadcast or reroute or supply conditions for digital communications online without any changes of the content, or they have intermediate storage and transiting in an automatic way through a transition, the supply of connections given digital connections online. In this whole field, we also have the suppliers of online services, and you know who, given an automatic process at the request of a user, or they will connect users to an online site through search tools. In regards to this figure, we established the so-called safe board that tries to limit its responsibility under in the possible committance of infringements. Under these figures, the PCI of origin are not responsible of the harms and damages that could take place within their networks, as long as they don't control, they start, or they lead all this infringing behavior. The online suppliers of promises were not responsible of any element when they retire the content, given a resolution of the competent authority or a request by the right bearer. Now, through this, we're complying with all of the commitments embraced by USMCA, such as the administrative officials at the working level and the standard that our main commercial partners are pointing out. Mexico has signed the main treaties and works in the areas managed by OMPI or WIPO, and the current administration is collecting all the elements considered within the USMCA, and now it has a broader name. Now, having said this, I have given you a brief presentation of what we are doing in Mexico formally. Now, we also do have, through the Institute, programs in place for the small and mid-sized companies. We're trying to foster the gender equity by providing counseling to inventors, women, which is one of the recurrent topics in the national and international agenda that has to do with the traditional knowledge and the protection of the community knowledge. We're trying to protect them within the framework of the protection of international treaties in intellectual international property protection. Well, if you allow me, this is part of the system that we are implementing at this moment. And well, I will leave it this far, and I hope I will be able to respond to your questions. Well, we thank you, Alfredo. It has been quite a positive presentation, and it has touched many areas in a very limited amount of time. I have several questions for you that come to my mind. It is possible that the audience will have questions for you. So I will repeat the fact that you can send your questions to our email, mexico at wilsoncenter.org, or in Twitter, Mexico Institute. And now we come into a conversation. So let me see if we have any questions from our audience. But Alfredo, maybe we can start with the USMCA. And well, Perhaps could you elaborate in regards to the implementation, in regards to the obligations that Mexico had and the necessary changes, and where are we within this process? Is this fully implemented or there's still steps to be taken? We have collected the main commitments. We believe that in numbers, we're up to, let's say, 90% of the percentage of our obligations fulfilled. Which is missing is the by role of the act in accordance to the mentional system. We can cover possible gaps or legal voids that industrial property will have. So with this as a secondary law that will give shape of how we will be working with specific areas foreseen within the law. Basically, let me say that we will be up to 90% as a result of the implementation of this act in 2020. We're missing this small part where we will have to have additional functions to all of the officers within this area. I think we're way ahead. We're always open to welcome comments of any pending issue in the implementation of our USMCA agreement. Now, in regards to the United States and Canada, the two partners are fully covering this area, or are they still missing some areas to be fully on the right side? Well, I think the Ministry of Economy will have to say this, but I think in the area of intellectual property, I think the three trade partners are compliant with this. Maybe there are some areas pending implementation, but so far I do not know about any serious delay. All of the topics have been covered. Thank you very much, Alfredo. And well, let me see that if we can elaborate about these area with more details. As I have mentioned during the presentation, uh, the concept of how we can connect this relationship between approval of the health documents and the patents. And personally, could you tell us more about how the collaboration, the coordination within COFEPRIS and IMPI is doing? That since I've been working in this area, it has always been complicated to say the least. Yes, of course. Well, once again, let's go back to the year 2003 when we started all these linking areas. Since we started this exercise, with no doubt there have been some failures, yet the number of held registries or licenses in accordance to the patents has gone up. I do not recall precisely the information, more than 5 or 6 cases that given any mistake of any of the government officials, a held license was given in relation to a patent, not because there was any doubt, but maybe it had not been questioned. In current cases, there are many questions regarding the scope of this, but there haven't been any flagrant cases here of non following up the rules on behalf of the government officials. If I am correct, under this area, there's also an obligation to recognize the patents. Yes, there are in this area of the USMCA has some room for discussion within our legislation. We have a protection to this type of patents. This at the national level, we have it protected in one way or another with the tool of how we are having this linkage. We're not giving them the right protection. Now, the text considers if we were going to be including in the discussions of the free trade agreement, the USMCA, all of these patents or not. This gave room to discussions because some interested in the area of patents consider that we were not going to be protecting this type of patents. Now, the national legislation, in summary, IMPI, grants and protects this type of patents, and the protection is given through the linkage and the different processes that we have in place for this specific purpose. Let's switch topics slightly, and I believe it is important that we go a bit more into explaining the efforts that IMPI is having in order to promote the entrance of the SMEs economy, uh, starting with the SMEs. And I wonder which are the efforts. I don't know if there are any specific efforts. And I wonder what IMPI is doing in order to promote more innovation, or that the SMEs are recognizing, or they identifying any possibilities in order to commercialize their innovations. Sometimes I imagine that they really do not understand how the whole concept of intellectual property functions. Well, let me say a good number of jobs and capacity of industrial development is generated within the SMEs and the small, medium sized companies. Now, it's important for EMP to be connected with the protection of industrial property for their licensing and for their use and registry. Now, in several administrations of the Institute have been trying to connect this area with our society. But the first element is promotion. We do not have any institution of industrial property in the world that will have enough money as to carry out the right promotion that will reach all levels of society. So, what is it that we can do in this administration? We're looking for partners to work with the different chambers, the universities and colleges, even with basic schools, in order to disseminate the topic of industrial property and to make sure that the use of industrial property is not only the fact of getting a registry of a brand or a patent or whatever the purpose of it, but we're also using open source technology that is generated within intellectual property area. There are many areas that were not registered in Mexico for many reasons. U.S. patents, European patents that are part of the Mexican market. We're trying to bring to the IT sector, the small and medium-sized companies, for them to know which is the development in the technological field and that they can use it within having to pay royalties. And even also to disseminate, as we have been doing in Mexico and in many offices, the protected patents in order to approach the possible users with patent right holders through the right fees and payments. So we have two lines: promotion and the outreach of the industrial property scope protection. And well, the idea is to give discounts in the fees that the Institute collects. We started last year with the handcraft industry. Through the officials that are regulating this field in Mexico, we reached an agreement in order to collect only 10% of the fee for the registry of trademarks, those companies that had to do with FORNART, which is the company or the officials involved in the protection of artisans' work. Now, this year, we will have a discount of 90% of the fees for the SMEs that will be directed to us by the state government. With this, we estimate to have between 3,000 and 3,500 applications of trademarks in the future that have to do with SMEs. Now, let's say that if I have a artisan's element, I can consider a mini SME, but through this, we are developing areas now that for the potential, but we have to highlight the use of the system that is not implicating records or licensing. But the very important thing has to do with fees. If we consider our economic capacity of an SME, maybe they will not give a priority, or it might not be an initial part of what they're doing regarding their trademark. That's why we are now developing a campaign so that the registry for these companies for a specific time will be the equivalent of $15 at the national level, with the same 10-year protection. In the area of patents, since we started the institute, we were giving a 15% for inventors, but now we're trying to focus in marks, in brands, in order to generate the connections that will connect industrial property with this sector of the Mexican industry. So it is only 1 year that the fees have gone down, right? No, no, no. Let me say, this was done last year for a month. The institute has to be self-sufficient in managing its resources, so we have to have a balance in regards to the discounts that we can give and what we need as income to operate the institute. This year, we're considering that from the intellectual property World's Day, we will launch a campaign for a month. If we're successful, we're estimating from 3,000 to 3,500 brands. Now, we want to disseminate this promotion and we want to reach a higher number. Now, this is what I was going to ask you. Now, have you seen already a considerable increase in the number of applications or something that could share or show that it has had an impact to have this reduction in the fees? I imagine that nevertheless, the owner of a company has to have knowledge of the concept of brands and marks to understand that there is this opportunity available. That is why we don't do it in an independent way by launching a campaign. We are connecting last year with the different organization of handcrafters and artisans with the different local governments to give a better outreach to this program. It was quite a success with artisans. A lot of people that would never approach our institute to register their brands do have it now. And as you know, most of the countries, the number of brands is going up year after year. We concluded 2021 with record figures going above 200,000 applications a year. That for Mexico is quite a positive number. Now, the problem is we need the time to process it. So we need a higher commitment on the government officials of the institute, but the number is increasing, and campaigns like this are helping us to increase this. And they are brands for physical products or IT or digital. We have all the different areas, but it has to be a both of the. Now these SMEs, we want them to continue operating. That means that the useful life of these small companies will not be 1 or 2 months, but by generating assets, they could remain longer within the market with the right competition conditions and all of the elements that we are generating from the government. Oh, well, thank you so much. Another topic that you touched a bit, Alfredo, in your presentation is this counterfeit concept, non-authorized products. And this is something that we see within the what we see in the border areas with IMPI, SAT, and other institutions of the U.S. government and the Mexican government. Well, I will start by saying how the system, Mexican system of enforcement operates. We have an administrative official, which is headed by IMPI, and we have the criminal official that will be the general prosecutor's office, the general attorney. But in the case of IMPI, we have tried to stop the import of counterfeit products. We're working hand in hand with SAT. That's why we have these elements of all the transportation and the transfers of this type of measures to try to limit this market. It's best to carry out an operation with customs before they enter the market instead of pursuing this in the different markets. Yes, we're working with the customs officials. Now it changed its name. It is National Agency of Customs. It is in a new process, but we have had good collaboration with them. With other officials from other countries, traditionally we were collaborating, basically with the United States, even with Interpol and international customs bodies. But the pandemic stopped the direct cooperation that we had. And now my intention is to say to the members of the IMPI to reactivate all of these operation and trading processes. We always have something to learn, and the information on this area is very welcome from the Mexican government. We have two scenarios, the counterfeits and the similarity that lead to confusion. IMPI sanctions both of them. This gives us a broader margin, and we're also fully aware of how the piracy has been evolving with counterfeit products. I mean, you have been to Mexico many times and you could find a lot of counterfeited products out in the streets. I'm not saying that this is no longer there, but Now it has different commercializing channels. We have a lot of this in the digital environment, and this is why the law has changed, and it allows the IMPI to be able to act in this new reality that has to do with virtual elements all over the world. And and yes, we see less out in the streets, but it doesn't mean that it's limiting. But now the regularization standards are evolving. We're working on this, and in shortly we will be reactivating our collaboration with other countries. It was nothing else that we had to stop these from implementation, but it had the presence of COVID and the pandemic. Many things in many parts of the world from the upcoming of this pandemic were impacted. It stopped a lot of the activities. Uh, that does not mean a lack of interest, but well, it was just impossible to travel, and sometimes it is not the same to try to have a virtual training. There are advantages of being present physically and to see things directly. Well, yes, basically in this type of problems that not only have to do with someone who is creating music at home. We can go to organized crime area, so it's best to work it with a level that will allow you to have physical meetings. A lot of people are not confident about talking to a screen of such delicate issues. It's not traditional piracy that we can, let's say counterfeit jeans. No, no, no. It has so many lines. And I mean, they're not lines that are present within just one country. This is international presence. So, yes, we may be facing organized international crime. And if I'm not wrong, Mexico had for years in place agreements with other countries in order to share their uh, investigations and analysis with other officials of smaller countries. Do you still have this in place? And can you share with us how Mexico is collaborating with Central America or other countries? Yes. Well, I believe that the main collaboration takes place with the customs officers. They are the ones that have a stronger organization. Now we're still working with Central American countries, what has to do with training in the digital environment, and which are the steps that Mexico has taken in this area. How are we promoting advancements, how we use them? And for many years, we have had the Central American Cooperation for processing patents. This does not much to do with the area that has to do with protection, but yes, we work with these within these areas in technical support, and we have a lot of collaboration agreements with Central American countries. Last year, in October and November, we worked in the Dominican Republic, Honduras, and Panama in order to share our experiences and also to learn precisely what is happening in these countries because the problem could be different in each of these countries. The goal is the same, yet the problem and the way of tackling these problems is different. Mexico shares its experiences, and we listen to what they have to say in these cases. I'm sorry I switched topics, but I was thinking more about the review of patents and not necessarily piracy products. Yes, yes. Well, in the area of processing patents, we're still working, and we've been working for many years with freedom that countries have deciding if it will grant or deny a patent presence. Sovereignty is fully respected. The agreement is only just to share the information and sharing the experience, but it is not leading us to the decision of granting or denying. It is the sovereignty of each country that decides. The intention is not to duplicate efforts. If an application is presented in Mexico and we're analyzing it, another country can dedicate efforts to their national applications and they don't have to have this burden. We are interacting with countries in Central America, South America, and also we are working with African countries in order to share our analysis in common patents and some other patents that were already registered in the country of origin, but not in Mexico. I think this is a very good example of cooperation and collaboration. This is with no doubt very important, as you're saying. that at the end of the story, it is the country that takes the decision if they will grant a patent registration or not. And well, if it has been done in another country, well, it doesn't have to involve all the work involved in this. And if you get patents like this, well, you reach solutions faster. There's another intention here that is to support the commercial sector in Mexico in this given case, that they will have the protection of their patents in other countries. If we have a regional safe environment, the Ministry of Commerce can grow and trade can grow. Now, we have a similar agreement, for example, with the United States. It was fully implemented last year in order to optimize our outcomes. The volume with the United States is much greater, and this has allowed us to reduce considerably the burden of the tramiting processes. And now it is a more complete and ambitious program that we have with the United States. And we also have one program like this with the European Patent Office. So then, with there is a pandemic that certainly had an impact in its ability to process applications, etc. But how much time will it take? Let's say that if I send an application today, how much time will it take me before I get my patent? With the mechanisms that we have currently in place, basically with the United States and the European Patent Office, we still follow international amounts. We're trying to have definitions and outcomes in 3 years. This is the international scale. If there are any programs like PPH, of course, well, CPH, well, programs can be limited, but in average, with these efforts in a joint way with other countries, we're talking about 3 years in order to obtain a patent. Alfredo, as I have mentioned at the beginning, you've been working at IMPI for a very long time. Could you share with us a bit about the changes that you have seen, or what is your perception of intellectual property from the beginning of your functions at IMPI and how we see it today? And where are we heading in regards to the intellectual property? Let me go back to 1994 when I joined the Institute. What is important then was the implementation of NAFTA. Mexico had a system in place that we could consider acceptable, but it was not modern enough. At that time, in the 90s, really the knowledge of the population in regards to industrial property was limited. There was a sector that was always actor, and it had to be connected with intellectual property, but we were missing an outreach of this information. Since the early 90s, we started to disseminate and have contacts with the universities and colleges, and the understanding of the system from the society has been increasing. There's still room for growth here. A lot is missing. But at the beginning of the 2000, we started putting regional offices in place that were bringing the system to the states of Mexico. Mexico is no small country. It's a very large country. So the outreach at this time that was not necessarily automatized or digital. We had to have physical presence. So we had to have training. So with all of these regional offices, it certainly helped us to disseminate this knowledge, and it would not be located only in the capital city, but all over the states of Mexico. Modernization came, the digital environment started, and we had all these changes and an advancement that we had not expected. And technology goes beyond the law. So then it was necessary to carry out the legislative changes. And now we have a new generation of that truly uses in the industrial property system, but they needed quick access. So to have the same language of the so-called millennials, I don't know how you call them in the United States now, but to be able to talk to them in their own language. And they were going to be presenting their physical elements. Everything was automatized, and this was quite the change that has allowed us to reach more sectors of the population. As I can share with you, it might be the case that now people know of the system, but we also needed the economic area. That is why we were having all these problems in order to promote the system. In summary, I think Mexico has moved forward in knowledge and intellectual property understanding, but we're still missing a lot of areas in patents, but at least the knowledge and the mention of intellectual property notion is already common in the whole nation. Industrial property is not understood as spacecraft or anything like this. I believe that people have a greater understanding of what it is and basically the area of what should not be done. Piracy had a socially acceptable behavior. Now we have a more awareness of how this impacts jobs. I think we're still missing a lot, but it is not only the topic of disseminating the system, but that the country will have the economic conditions for the adequate use of industrial protection. Well, I believe that I have to thank you for this concept. I believe that it goes to a better understanding of the danger that pirate products imply. Also, talking about different types of medical drugs and other things. So, well, you say, well, this is the same, but it's cheaper. And so, to have a better understanding in the younger generations of the risks, and as we say in English, you get what you pay for. So, if you pay less, well, the products are of lesser quality and it could be a dangerous product. Yes, let me share with you a reflection. In the 70s, we didn't hear this. The idea was if you were forging a pair of jeans, nothing happened. They just will make less. But now there is an awareness of what it means to buy, for example, counterfeit drugs or spare parts. We have found spare parts for the aerospace industry and they're counterfeited. So now people understand what it means in regards to the loss of jobs and the illegal software damages that it can damage your information. It can make it public. I think we have moved forward globally in this regard, but I think Mexico has a greater responsibility in regards to what it means to consider counterfeit products and also access to goods and services. That's another area. So I'm not going to buy if I can purchase an original product in regards to the prices. But if an original product is accessible in my purchasing power, I will not be looking for products. So this is a group of social and economic topics that have a tremendous weight. Yes, of course, it is a very important point, of course, that with the USMCA and with the growth of digital trade, products are more accessible and it's less important where they are. And if you have access to internet, you can get products anywhere in the world. That is right. Technology has been making sense to protect intellectual property, but it opened up a line to obtain products that are authentic, that will not generate a greater harm or damage to the society. Well, now we're reaching the end of our time. So I wonder if we can end up with our perspective about the future and in regards to USMCA. You will be having an important meeting in 2026 where the parties will have to review how USMCA is operating and to decide if you will move on or stop it. How do you see it? I have two combined questions. One of them is what can we do to ensure that the people will receive and recognize the benefits of USMCA, thinking basically in terms of industrial property? And what else can Mexico do to ensure that the governments of the United States and Canada will look at Mexico as a good partner in regards to the intellectual property terms? Your first question, sir. Well, people are looking at the benefits of the free trade agreements, access to products, quality, costs. So what I believe that we have to do now is to explain where these benefits come from and the rules to have access to our commercial partners. We have to be respectful of the legislation in order to have the quality and the trust of our trade partners. People have seen the benefits in the 80s. Basically products were scarce in Mexico. Now we do not have that problem. As an administration, we have to keep a legislation that will allow us to retain the standards of our trade partners, but basically to make sure that there is a true enforcement of all of this legislation in the country. And of course, the benefits for people are direct here. And the issue is to explain to them what this means and which are the behaviors that the government has to implement. With no doubt, I started working in the uh, NAFTA generation. I cannot see a North American region without free trade agreements, but we have to update our legislation and to keep an eye in how things are moving forward. I remember that one of the priorities in Mexico is let's be respectful of the intellectual property right. We have been instructed to always safeguard the interests of industrial protection. That has been one of the main purposes of this administration and previous one. Yes, I believe there is a unanimous uh, consideration within the political parties in the United States and Mexico and everywhere in regards to my personal impression here is that the concept of industrial and intellectual property protection is not a political issue. I've never seen any administration or government or political party that will not be in favor of this intellectual property protection. Well, basically, we have to have the tools to generate more resources among the three countries, that the exchange of information and investment will be safe, always considering the premise that intellectual property is a tool and is not the final purpose of this legislation. Certainly, the three countries can move forward. Every country has different problems, and sometimes we can have some problems with a specific area, but international treaties and legislation could settle these problems in order to develop the trust among the population within this system and our society. I think that is critical. Yes, I believe that is the right expression. I think that the possibility that I can use and protect my innovation that gives me a true promotion in continue inventing and continue trying to develop new products, new innovations, and new ways of doing things. That is why to have a patent in place is really very important. And also, all of these things are relevant to facilitate and promote innovation. It's been very difficult to disseminate among the society the intent, what innovation and development means, and that industrial property is a tool, is not the final purpose of this to protect it. It's for innovation and development. It will give us elements in order to protect and achieve this. Well, Alfredo, thank you so much. We have a few questions. Let me see if you have any final topics. I think we have touched so many areas in a limited amount of time. We are extremely efficient, but if there's anything that you miss saying or you would like to mention, no, I simply would like to share a conclusion. But a priority of the Mexican administration in this administration is the full respect of intellectual property rights and basically coming from the situation that it is a tool for innovation and development to generate also trust within the international markets in the industrial property. Mexico will be fully responsible and responding and complying with the international treaties. Well, Alfredo, we know you have a lot of work and we're having to manage such an important institution as IMPI. We thank you for your time and we hope to meet again in an additional presence opportunity. But at least we had this opportunity of being virtually. We thank you for being with us. We thank all our audience for their participation today in this event. And well, and we're always open We are always open to continue our collaboration with IMPI. Thank you very much for all the logistics and the time that you dedicated to have this webinar. Thank you very much and good evening. Have a wonderful afternoon.